Whose bag is this? Whose bag is this? Let's move this. You guys are starting, right?
Yeah, she's going to start with them.
Okay. Where are you sitting?
May I please report, my lady, I confirm the Inspector of the State, the appearance is asked to speak.
As the court pleases, my lady, I appear on behalf of the Cradock core families, together with my Bernard Jr., Mr. Zach Suleiman, instructed by Cliff Hoffman.
May it please you, my lady, Miss Poison, Miss Kezi, and I appear for the Cradock community on behalf of Mr. Mbulelo Goniwa. Thank you.
May it please the court, my lady, NMW from Salvation, I appear on behalf of the General from the Best State.
May it please the court, my lady, J.G. Singira, SC, from the Victoria Bar on instructions of Mr. Miller on behalf of certain individual members of the police, General Erasmus, General Engelbrecht, and Mr. Williams.
Lady, the Mayor from the Mayor of Kennedy, I appear on behalf of Mr. Barton from the servant of the Mayor.
May it please the court, Lady Skuman, initials J, appearing on behalf of Eugene Nicole. May it please.
Please, my lady, I appear on behalf of the South African Police Service in the matter.
May it please, my lady, Finish Schneider from Legal Aid South Africa, my lady.
Before I call upon the parties or the representatives of the parties to make their opening addresses, I wish to raise the following. This proceedings concern the reopening of an inquest into the death of 4 persons, those being Mr. Matthew Boniwe, Mr. Sparo Nkondo, Mr. Fort Talana, and Mr. Sicelo Mhlauli. The 4 are collectively known as the Cradock 4. Inquests into the deaths of the Cradock 4 were held on 2 previous occasions. The first one was presided over by a regional magistrate during, I believe, 1989, and the second one was presided over by a judge of the High Court during 1993. The purpose of an inquest is to establish whether the death of any person who died of causes other than natural causes has been brought about by any act or omission involving or amounting to an offense on the part of any person or persons. In the previously held inquests, the presiding officers concluded or held that the deaths of the Cradock 4 were brought about by a person or persons unknown or unknown persons. The parties will correct me or will confirm. In my understanding, or as I understand, I will be required to make a finding only in this regard, in the last mentioned regard, namely as to whether the deaths were brought about by an act or omission prima facie involving or amounting to an offense on the part of any person or persons. And that the identity of the deceased persons, the cause or likely cause of their demise, and the date of their death are by and large factors that are in dispute or are not in dispute or common cause. So I will now call upon the parties to make their opening addresses.
Thank you, my lady. For the sake of progress, we confirm that we made a statement on the 2nd of September 2024. So we refer your ladyship to that statement. For the sake of progress, we're not going to repeat anything in that regard. Lady, what we wanted to, however, place on record is that, firstly, in respect of the issue regarding legal representation, because that was the issue that also caused the matter to be postponed the last time, we can place on record, and I'm sure the legal representatives will also further confirm that, is that the legal representation in respect of the former members of the South African police have been sorted out. So, but I do know that that has only been done in the last week or so. In respect of Mr. Mbulelo Goniwe and the Cradock community, but I understand that there is an issue regarding that. My learned friend, Advocate Mukai Toby, will explain the position in that regard, but their legal representation has also been finalized and approved. Unfortunately, with regard to the South African Defence Force, former member of the South African Defence Force, and that is former General van der Westhuizen, his legal representation has not been finalized yet. In fact, there has been no response from the South African Defence Force, and we know, for instance, that at a recent hearing by the Justice and portfolio committee, that issue had also been raised, but there was no representative for the South African Defence Force at the hearing, and the chairman had made a ruling there that a letter be sent to the minister for her attention to address that issue as a matter of urgency. However, my lady would recall that this issue had been addressed since even before the 2nd of September last year, and that we had received absolutely no response from the South African Defence Force. We will therefore request your ladyship and my learned friend, my colleague, Mr. Governor, will address that issue if necessary. We will prepare a subpoena in respect of the official met the State Attorney dealing with this issue, as well as the legal officer at the South African Defence Force, which subpoena we will arrange to be issued today, and we will also arrange for those subpoenas, in fact, to be served on both of those officials for them to appear before this court, and hopefully by Monday, my lady. But hopefully it will not be necessary to go to the most extreme action in that regard. They are, my lady, but they haven't, as I understand it, and I'm sure Advocate Van Zyl will address that point. I don't think the SADF has filed an answering affidavit.
I might mention we filed an urgent application in February, beginning of March. We were heard early April, and the matter was struck from the roll due to a lack of urgency. So the matter is still pending, the review application. We have not been allocated a date on the normal opposed roll, despite various letters by my attorney addressed to the Registrar of the High Court in Pretoria. So the review application is still pending, but we don't know when it will be heard. Court, please.
I can just maybe confirm on behalf of the members of the police that I represent my learned colleague is correct. During the past few days, our situation has been resolved, and they agreed to pay the legal fees.
Thank you, Mr. Silio. Yes, Mr. President.
Thank you, my lady. So, my lady, that's the issue regarding the legal representation. So, what we intend doing, as we informed your ladyship in chambers, is to first have the inspections in loco. So, and we've arranged that we travel to Cradock, Nuba, the name is presently known, town, tomorrow, where we will ask the court to attend the family home of Mr. Matthew Goniwe, which house had been scoped in 1984 to ascertain whether it was possible for that house, for Mr. Goniwe to be killed at his home. And from there, we will then move to the Garden of Remembrance that had been erected in memory of the 4 deceased and other activists. And on our way back, we will attend the scene at the Olifants Kop Pass, where these activists had been abducted and taken to Port Elizabeth, where they'd been killed, or Gavega. And then on Wednesday, we will have the inspections in loco here in Gavega at the various scenes, including the scene where the burnt-out car of Mr. Goniwe had been found. And for Thursday, we have arranged for Professor Derek Swartz to come and testify. We've had to make special arrangements with him as he is traveling extensively, and he needs to travel to, I think, China on Friday. So we've agreed that his evidence be laid on Thursday, and thereafter it will be the family witnesses. That is all.
And this evidence is not likely to implicate any of the persons of interest?
No, my lady.
Yes, you can proceed, Mr.
That is all. Thank you.
Mr. Vanning?
As the court pleases, the lady on the 27th of June 2025, just over 3 weeks' time, we will mark the 40th anniversary of the brutal killings of Matthew Ganiwe, Fort Kalata, Kelo Mshlali, Sparrow and Hunter, collectively known as the Cradock Four. After 40 years, the families are still waiting for justice and closure. The lady, before I proceed, may I hand up a copy of my heads of argument? We do have some copies for our colleagues, which we will distribute. The lady on the 27th of June 1985, they were abducted, assaulted, murdered, and their bodies burnt by the security branch of the erstwhile South African police. They were murdered as part of the apartheid regime's ruthless campaign against those mobilizing resistance to the pernicious system of racial oppression. The stories of the lives of the Cradock Four, their struggle for freedom, and their untimely deaths are etched into the history of South Africa. These were 4 young men who had so much to offer South Africa. They were visionaries and leaders. The lady post-apartheid South Africa is a poorer place without them. We could have used their guiding hands and wisdom. They would have inspired us to do better. Most of all, they were dearly loved and treasured by their families, friends, and comrades. The searing pain of their absence persists with the families to this day. My lady, in this first session of the third inquest into the death of the Cradock Four, we will hear from the following family members: Rukanya Kalata, son of the late Fort Kalata; Namonde Kalata, wife of the late Fort Kalata; Dorothy Kalata, daughter of Fort; Tamani Kalata, also daughter of Fort; Monwaba Mkonto, son of the late Sparrow Mkonto; Nyanise Ganiwe, son of the late Matthew Ganiwe; Mbuyi Mshlali, wife of the late Gela Mshlali; Itsika Mshlali, the son; and Gobani Zonke, brother-in-law of the late Mshlali. We will also hear from Inquest Domini Charles Kutsia, who presided at a reconciliation meeting between former Security Branch Officer Eric Taylor and several family members. The lady at this meeting, Taylor, confessed to his role in the killings. He is now deceased. Turning to the case of the families, my lady, we intend to demonstrate that the deaths of the Cradock Four were brought about by way of a calculated and premeditated decision of the apartheid regime, taken at the highest level of the government state security system. It was then meticulously planned by the security branch in an official operation. My lady, this was no private frolic or errant police officers departing from official instructions or policy. The killers did exactly what they were told to do and exactly what was expected of them. In the early to mid-1980s, the Eastern Cape, and Cradock in particular, was the epicenter of the fight back against apartheid. This resistance was led by Matthew Ganiwe, Fort Kalata, Imbelela Ganiwe, Sikelo Mshlali, Sparrow Mkonto, Madola Jacobs, and many others. They established local organizations and street committees in virtually all towns in the regions and were able to mobilize thousands to come out onto the streets. Further afield, in Port Elizabeth and elsewhere, community leaders like Sipa Charles Hashe, Kwakwalu Gudozoli, Champion Galele, Simpiwe Ntumkulu, Topsy Madaka, Izingziwe Kondila were similarly mobilizing. The apartheid state did not know how to deal with this rising tide of defiance. They tried just about everything in their security toolbox. Multiple detentions without trial, a slew of death threats, acts of arson and intimidation, orchestrated firings from public and private posts, disinformation and propaganda. Milady, none of it worked. Indeed, it only emboldened the activists and fired up their supporters. So from the early 1980s and culminating in the mid-1980s, the security forces opted for more permanent solutions to these troublemakers, namely extrajudicial executions, or to coin security speak, elimination or permanent removal from society. In 1981, the security branch abducted, tortured and murdered COSAS activist Kwezi Kondile, and his body was found burnt. While in 1982, they kidnapped, tortured and murdered COSAS activists Sipiwe Mtimkulu and Tobakile Topsy Madaka, whose bodies were also found burnt. The 3 security branch officers associated with the Cradock 4 case, Nicolaas Janse van Rensburg, he was second in command of the security branch in Port Elizabeth at the time, Gerrit Nicolaas Erasmus, who in 1984 was the head of the security branch in Port Elizabeth, and Hermanus Baron du Plessis, he was the security branch head of Black Affairs in the Eastern Cape region. They were granted amnesty for the kidnapping and murder of Kondile and also Mtimkulu and Madaka. Milady, just a few weeks before the Cradock 4 murders, between 8th and 10th of May 1985, the security branch conducted a similar operation against Hashe, Gorolozi, and Galela, famously known as the Pepco 3. The 3 civic activists were abducted from Port Elizabeth Airport and removed to the isolated Post-Chalmers farm, where they were tortured and murdered. 4 of those who applied for amnesty in that matter were also involved in the Cradock 4 killings, namely Harold Snyman, who in 1985 was the head of the security branch in Port Elizabeth, Hermanus Baron du Plessis, Johannes Martin van Zyl, also known as Saki van Zyl, and Gerhardus Johannes Lotz. Lady van Zyl and Lotz were members of the security branch based in Port Elizabeth. All except Snyman were denied amnesty. In his amnesty application, van Zyl said his murder weapon in the Pepco 3 murders was an unlicensed .22 caliber firearm, which exactly matched the description of the firearm he used to murder Sparrow Mkonto. The Cradock 4 murders were hardly an isolated event. It was rather part of a systematic program of abduction and murder of leading anti-apartheid activists in the Eastern Cape at this time, involving considerable overlap in those involved in the planning and execution of these crimes. It is important to set the scene, to look at the context of what was taking place in Cradock and the Eastern Cape in the early 1980s. And I'll start in 1983. In that year, Matthew Ganiwa and Fort Galata spearheaded the setting up of the Cradock Youth Association, known as Cradoya, and the Cradock Residents Association, known as Cradora. They and others led protests against high rentals imposed by the local administration board. Ganiwa and his comrades set up United Democratic Front structures throughout the Eastern Cape and engaged in mass action against the dictates of apartheid local government entities. In order to neutralize the impact of Matthew Ganiwa in Cradock, the security branch placed pressure on the Department of Education, which I refer to as DET, to remove him from Cradock and DET complied by transferring him to a school in Graafrenet in late 1983. However, Geneva refused the appointment, and when he did not report for work in Graafrenet, the DET told him he had dismissed himself, and he was officially fired on 27 January of 1984. This sparked a massive school boycott which lasted some 15 months. In March 1984, Geneva was appointed as the UDF's rural organizer, and at this time he was also placed under permanent surveillance by the Cradock Security Police Chief, Major Eric Winter, and the local magistrate banned all Cradora and Cradock meetings, sparking unrest on the streets. On 19 March 1984, at a State Security Council meeting, then Black Education Minister Barent du Plessis, according to the minutes of that meeting, proposed the removal of Geneva. And I'll quote in Afrikaans what was recorded in that minute. In Cradock is daar twee oud onderwysers wat as agitators optree. Dit sou goed wees as hulle verwyder kon word. Translated into English as, in Cradock, there are two teachers who are acting as agitators. It would be good if they could be removed. The lady had emerged from the amnesty application of Security Branch Officer Jacobus Jan Hendrik van Jaarsveld that within 2 days of that meeting, Security Branch Intelligence ordered operatives to proceed to Cradock to investigate the best way to take out Geneva and Kalata. And in his report to his superiors, Van Jaarsveld cautioned against attempting to kill the targets in Cradock and proposed that they be taken out on a deserted road. Some 11 days after the removal of the ex-teachers was urged at that State Security Council meeting, on 30th March 1984, the security branch swooped at night and detained Geniwe Kalata and Imbelela Geniwe. 2 days earlier, they had already detained Fazila Donald Madoda Jacobs, who was the head prefect at the local high school. They were detained under Section 28 of the Internal Security Act. So, milady, the request at the State Security Council was in fact acted upon, and they were removed from the community. On 31st March 1984, the Minister of Law and Order, Louis Lagrange, banned all meetings for 3 months, prompting ongoing mass protest. Police and the South African Defence Force cracked down and cordoned off Lingashlile Township, searching for suspects. After the police tear gas most of the township on 15 June 1984, the community began sporadic boycotts of white-owned shops. Geniwe and the others were released after some 6 months on 10th October 1984 to a hero's welcome in Cradock, and they immediately called for a Black Christmas, extending the boycott of white-owned shops. Lingashlile was one of the first townships to introduce street committees under the guidance of Geniwe and Cradora. Some 17,000 residents were divided into 7 zones. About 40 activists were assigned to each zone and held meetings to elect officials. Each household could vote for their street representatives. This was known in some circles as the G Plan, or Geniwe's Plan, and this was replicated throughout the region. In 1985, Geniwe was appointed UDF organizer, and he and his comrades established liberation associations and sector organizations in some 56 communities throughout the region. So, my lady, let's now turn to 1985, the year in which the murders took place. By early 1985, Matthew Geniwe's national and international stature had grown considerably. In January, he was visited by US embassy officials, and later that month he travelled to Cape Town to meet Senator Edward Kennedy. In the first few months of 1985, he called for calm in Cradock and held meetings with the DET, the Education Department, to discuss his possible reinstatement and the ending of the school boycott. Indeed, the DET even agreed to help the holding of a rally, notwithstanding the imposition of a ban on public meetings, so that Matthew Geniwe could call for an end to the school boycott. And indeed, this happened on the 29th of March 1985, and the boycott was called off in early April of that year. In May 1985, when it appeared that Geniwe would be reinstated, the army and police raided Lingashlile Township, which was sealed off, and pamphlets linking Cradock to violence, communism and terrorism were dropped from helicopters. The police used loudspeakers to personally slander Gniwa from those helicopters. On the 23rd of May 1985, the Deputy Minister of Law and Order, Adrian Vlok, visited Port Elizabeth and Cradock. On that same day, the Eastern Province Joint Management Committee, known as the JMC, met to discuss how to handle Gniwa. The meeting was chaired by local Army Commander Brigadier CP Joffel van der Westhuizen and attended by regional security police officers, including the local chief Harold Snyman, amongst others. After the meeting, Deputy Minister Vlok phoned the Minister of Education to delay any reappointment of Gniwa until Law and Order Minister Louis Lafranji had discussed the matter at an upcoming cabinet meeting. Also following that meeting, van der Westhuizen sent a signal to the State Security Council Secretariat in Pretoria, urgently recommending that Gniwa and Kalata should never ever be reappointed to any post in the DET under any circumstance. And that signal was sent by Military Colonel Lawrence du Plessis. The next day, on Friday, 24 May 1985, DET official Jaap Strydom and DET's Deputy Director of Communications, Johannes Vermaak, actually met Matthew Gniwa at the Masonic Hotel in Cradock to discuss his future in the department. Gniwa was told that only the minister could reappoint him. At the beginning of June 1985, Eric Winter, the commander of the security branch in Cradock, ordered an intensification of the surveillance on Gniwa. By this time, they had already planted what's referred to in police terms as a tomati, translated as a tomato, which is a bug in the house of the Gniwa home. They were listening to conversations, and needless to say, the telephone was also bugged. On 5th June, activist preacher, the Reverend Alan Bussack, prominent UDF activist, visited Cradock and spent the night talking to Gniwa. On Thursday, 6th June, the DET's Jaap Strydom travelled to Cradock again and appeared to support the case for the reinstatement of Gniwa, but this was against the wishes of the security hawks. In response, Snyman wrote to the State Security Council urging that Gniwa should not be reappointed. On 6 June 1985, the State Security Council's Joint Security Action Committee, in a meeting chaired by Adrian Vlok, he sought recommendations on what to do about Gniwa. A subcommittee was appointed under Brigadier Pieter Geldenhuys to make recommendations. On Friday, 7 June, Major General J. Frederick Johannes van Rensburg of the State Security Council Secretariat phoned Brigadier van der Westhuizen to discuss Gniwa. The two officers apparently decided that Gniwa and two others, Fort Kalata and Belela Gniwa, should be permanently removed from society as a matter of urgency. Van Rensburg indicated that he wanted a submission to this effect from van der Westhuizen because he wished to brief the Special Works Committee on the same day. As a result of this discussion, Colonel Lawrence du Plessis sent a signal message form dated June 7, 1985, addressed to the State Security Council Secretariat and detailing the earlier discussion. It was marked urgent and top secret. Because this will feature prominently in this inquest, I'm going to read what that signal stated. It's been translated into English. Personal for General van Rensburg. Telephone conversation, General van Rensburg struck Brigadier van der Westhuizen on 7 June 85 refers. Names as follows: Matthew Gniwa and Belela Gniwa, in brackets, brother or nephew of above. Fort Kalata. It is proposed that the above mentioned persons, as a matter of urgency, be permanently removed from society. Wide reaction can be expected locally as well as nationally as a result of the importance of these persons, especially the first mentioned for the enemy. For example, interdicts as recently with the disappearance of Godolozi, Haishe, and Galela, in brackets, PEPCO officials. Reaction from leftist politicians such as Molly Blackburn, and lastly, protests as in the case of Oscar Mpete in sympathy. Now, my lady, the reference to the litigation around the disappearance of Budolozi, Hasher and Galela, the Pepco 3, is most telling, since just weeks earlier they had been abducted and murdered by the security branch and their bodies burnt. And the legal action referred to in that signal were in fact the high-profile habeas corpus applications brought on 19 May 1985 by the families of the Pepco 3 against the police to produce their bodies. My lady, less than three days later, on the 10th of June 1985, at a meeting of the State Security Council, Deputy Law and Order Minister Flock indicated that he would take steps to allow the JMCs to act on their own initiative. There was no coincidence, my lady, that the key masterminds behind the operation sat on the Eastern Province JMC. And then on or about 12 June 1985, less than 2 days after the State Security Council meeting, Security Branch Officer Saki van Zyl and his team commenced planning for an operation to murder Ganiwe and the others. His instructions were to make the murders appear to be the result of a vigilante attack, which was a common cover-up tactic of the security forces at the time. Van Zyl was assisted by Lieutenant Eric Alexander Taylor, Sergeant Gerhardus Johannes Lotz, Warrant Officer Imbalala Glenn Ngoduka, Sergeant Amos Tembafaku, and Mr. Malile Shepard Sakati. According to Van Zyl, Taylor and Lotz, in their amnesty applications, they acted on the instructions of the late Nicolaas Jacobus Janse van Rensburg, second in command of the security branch in PE, and Hermanus Baron du Plessis, security branch commander for black areas in the province. And those two authorized the murders. According to Janse van Rensburg, he received instructions from his immediate superior, the late Harold Snyman, at that time head of security branch in PE. Snyman in turn stated that he was told by the former Minister of Law and Order, the late Mr. Louis Lagrange, to deal with those in leadership positions who were directly responsible for the unrest in the Eastern Cape. Meanwhile, the Special Works Committee under Peter Geldenhuys, working on the Ganiwe problem, considered various options with what to do with Ganiwe and made a report on 12 June in which Ganiwe's reinstatement was recommended. Now, it's unclear exactly what happened to the signal and how it was handled at the State Security Council. In the Zitzman inquest, Van Rensburg claimed that together with the Geldenhuys committee report, he tabled the signal from Van der Westhuizen verbally at a State Security Council meeting, although others have disputed this. On 27 June 1985, the Cradock 4 were abducted on a deserted road, as exactly recommended by Van Jaarsveld a year earlier, and murdered. The killers on the scene that night were Major Johan Martin Saki van Zyl, Lieutenant Eric Taylor, Sergeant Gerhardus Lotz, Sergeant Amos Faku, Sergeant Glenn Gonduka, and Shepard Shakati. According to the autopsy reports, Ganiwe Mhlali died from multiple stab wounds. Kalata died from a stab wound in the heart, and Konta died from a gunshot wound to the head and a stab wound to the heart. Mhlali's body was missing the right hand. The lady, it's quite apparent that before death, all four were brutally tortured and mutilated. The government and police fabricated a cover story claiming that the Cradock 4 had been killed by elements from the Azanian People's Organization in a factional dispute. And lady, we believe that the role of the State Security Council and its subordinate structures in authorizing or tacitly approving the elimination of the Cradock 4 should be closely investigated by this inquest, and this will require close examination of the state security chain of command and how that system worked. Lady, the State Security Council and its structures assume decision-making powers far beyond the advisory powers conferred to it by its Enabling Act. It was in that council and not cabinet where matters of greater sensitivity and importance were deliberated on, agreed upon, with cabinet typically providing just a rubber stamp. The State Security Council met fortnightly to discuss security issues and approve steps to be taken by the various arms of the state to turn back the tide of the revolutionary struggle. It was in these meetings that decisions were taken to impose states of emergency, ban organisations and launch cross-border operations in neighbouring states, and sometimes to take individuals against specified persons, take actions against specified persons. Operations were conducted through a system called the National Security Management System, NSMS, which was a vast bureaucracy coordinating all departments to counter the perceived total war against South Africa. It was through this system that the doctrine of total strategy was embraced and expounded, and where actions both legal and illegal were authorised through a hierarchy of some 500 regional, district and local joint management centres. The Truth Commission concluded in its final report that the State Security Council played a central role in the regime's shift from a legal response to an extra-legal response to the growing threat to the apartheid state. According to the TRC, the State Security Council initially targeted members of terrorist groups based outside South Africa, but from the early to mid-1980s, it began focusing on opponents within South Africa. SSC documents never directly used the word murder in its deliberations, but resorted to euphemisms such as eliminatie, verwyder, neutraliseer, and uitwis, loosely translated as eliminate, remove, neutralise, and wipe out. The Truth Commission concluded in its final report that State Security Council members, particularly representatives of the security forces and ministers in charge of security portfolios, reasonably foresaw that such words could be interpreted by members of the security forces as authorization to kill anti-apartheid activists. Lady, it will be our submissions that those serving on the State Security Council and or its structures were either party to the issuing of instructions, such as the elimination of the Cradock 4 and its cover-up, or were kept informed of such plans and what transpired in the aftermath. Lady, we are not aware of any State Security Council member or official who objected to the systematic killing of anti-apartheid activists, who sought an independent inquiry into the ongoing murders, or who issued any clarifications regarding its directives and specifically ordered the halting of such illegal operations. In the circumstances, even if the State Security Council members and its officials cannot be directly linked to such operations, they must still be held to account for their roles in tacitly approving the operations and choosing not to take steps to stop them and punish the perpetrators. Lady, turning to the aftermath, which is titled in our heads as Justice Denied, 2 inquests failed to get to the full truth. The first inquest under Magistrate De Beer was a whitewash, stage managed by the security branch and the justice authorities at the time. The second inquest under Judge Neville Zeetsman opened after a newspaper, The New Nation, on 8th May 1992, published a copy of the top secret permanent removal signal. Although the Zeetsman inquest could not identify who the killers were, it found that the signal was a recommendation to murder and that the security forces were responsible for the deaths. And it found that a case of suspicion had been made out against 2 police officers and 3 military officers. Notwithstanding these findings, nothing happened. As far as we are aware, these findings prompted no further investigations. 8 of those connected to the murders applied to the TRC for amnesty, including 3 of the masterminds, Hermanus Baron du Plessis, Nicolaas Jacobus Janssen van der Rensburg, and Harold Snyman. And 3 of the killers on the scene, Johan Martin Saki van Zyl, Eric Alexander Taylor, and Gerhardus Johannes Lotz, and 2 who played a peripheral role, Jacob Jan Hendrik Jaap van Jaarsveld and Eugene de Kock. All except for van Jaarsveld and Eugene de Kock were refused amnesty in 1999. Now, notwithstanding that all the masterminds and killers who applied for amnesty were denied amnesty, the post-apartheid authorities took no steps against them. Instead, they waited until more than 20 years had passed, until 2019, when the families again urged for action to be taken with the pro bono support of law firm Cliff Decker Hofmeyer and the Foundation for Human Rights. And lady, by then, most of the suspects against whom there was a prima facie case had already died. At first, the families thought that such an action was the product of a toxic mix of idleness, indifference, incapacity or incompetence on the part of the police and prosecutors. They now know, my lady, that something more sinister was at play and that political forces intervened to block their cases from proceeding. This was exposed in civil proceedings brought by Tembi Simelane in 2015 in respect of the 1983 abduction and murder of her sister, Nokutula. In that matter, the former National Director of Public Prosecutions, Advocate Vusi Pikoli, and the former head of the NPA's Priority Crime Litigation Unit, Anton Ackerman, SC, confirmed that political interference had closed down their investigations into the TRC cases. It's apparent, my lady, that the Cradock 4 case received little or no attention post the winding up of the TRC. Indeed, the investigation docket actually went missing from the NPA's offices between 2013 and 2019. This required the docket to be reconstructed. My lady, certainly in the past, certainly in apartheid days, missing dockets were typically an indication of a cover-up or an attempt to sabotage an investigation. And since it appeared that no investigation was launched into the disappearance of the docket, Lukanya Kalata was forced to open a case of theft in 2020. My lady, we will hear from Lukanya Kalata of the difficulties he had in simply opening up that case. That investigation was closed in August 2021 without providing any answers. On 29 August 2020, Nyameka Ganiwe, wife of Matthew Ganiwe, passed away. And sadly, her daughter Nobuzwe died recently in 2024. Lady, they died before seeing justice done. The cruel indifference of the apartheid South African state robbed them of peace and closure. Since all the efforts by the families and lawyers to get the authorities to finalise the investigations to come to naught, they launched an application in the Gauteng Division of the High Court in July of, I believe it was 20th of July 2021, against the NPA and SAPS. The family sought an order compelling them to finalise the investigations and make a decision whether to prosecute or not. Lady, the historic compromise which gave birth to the new South Africa demanded that those perpetrators denied amnesty or who did not apply for amnesty would face follow-up. They would face consequences. Lady, by and large, this has not happened. The state has instead systematically and deliberately dragged its feet or blocked justice in this case and the other TRC cases. And, my lady, we believe that this occurred probably at least up until around 2017. In order to vindicate their deeply violated rights, some 25 families and the Foundation for Human Rights launched an application on the 20th of January 2025, earlier this year. Lady, they are seeking a declaration of the family's rights. They're seeking constitutional damages, as well as an order compelling the President to establish a commission of inquiry into why their cases were suppressed. Lady, I'm pleased to advise that the President recently promulgated in the Gazette the establishment of such a commission. Lady, turning to the prospects of truth and justice, which we would submit are fast fading. Even before the launching of the family's application, the civil application in July of 2021, more than 10 suspects in the Cradock 4 case had died, including all members of the security branch hit squad. And since launching that case, another 5 persons of interest have passed away. And with the death in May 2023 of the last remaining suspect, Hermanus Baron du Plessis, against whom there was a prima facie case, they had to accept that a criminal prosecution in this matter was highly unlikely to happen. In August 2023, the families agreed to the holding of a third inquest, which was announced on 5 January 2024, and which was meant to start on 2nd September last year. But as my lady is aware, that collapsed since the persons of interest claimed that the NPA notified them too late to make timely arrangements for their legal costs. Indeed, even today, some of them, or at least one of them, are still litigating with the government on this issue, which explains why they are not testifying over the next 2 weeks. Lady, the bulk of apartheid-era cases have come to an end because suspects and witnesses have died, not to mention family members. The primary reason behind this monumental failure of justice has been the political interference which effectively killed off most of the TRC cases. The vast majority of cases cannot be resurrected at this late stage. In the Cradock 4 matter, we have identified some 49 persons who were associated in one form or another with this case. Virtually all of them have died. As mentioned, all 6 members of the police hit squad have died. All the masterminds against whom there was a prima facie case have died. Most of the members who sat on the State Security Council between 1984 and 1985 have died. Since the families launched their application to compel the NPA and SAP to take action in July 2021, the following persons of interest passed away. Eric Winter, former Cradock branch commander, died on 18 August 2021. F.W. de Klerk, former state president, died on 11 November 2021. Johannes Velder van der Merwe, former SAP commissioner, died on 27 August 2022. Adriaan Vlok died on 8 January 2023. Lucas Daniel Neil Barnard, former director of National Intelligence Service, died on 13 January 2025. And as mentioned, Hermanus Baron du Plessis, former head of branch Black Affairs and PE, died on 16 May 2023. That he was the mastermind behind the gruesome murders, not only of the Cradock 4, but also the Pepco 3, Sepiwe Ntunkulu, Topsy Madaka, Izimziwe Kondila, amongst others. All were tortured and abused before their deaths. My lady and I respectfully viewed as unforgivable that the authorities allowed du Plessis to go to his grave without facing justice. The families have had to accept that after 40 years of waiting, 31 of them in the post-apartheid era, they are unlikely to see justice done in this case. Given the ongoing and shameful delay by the authorities to sort the legal fees of the former state officials, there's a high probability that the few remaining key witnesses, who are all in the twilight of their lives, may not testify in this inquest because of death or infirmness. They include 88 years old Gerrit Nicolaas Erasmus, former Lieutenant General and head of the Port Elizabeth Security Branch, 85 years old Baron Jacobus du Plessis, former Minister of Black Education and also sat on the State Security Council, 84 years old Isaac Johannes Krappies Engelbrecht, former Major General and head of SAP's Counterintelligence Department, 82 years old Christoffel Pierre Joffel van der Westhuizen, former Lieutenant General in the SADF and former Officer Commanding EP Command. And we hear from his legal representative that he is in poor health. We did attempt to take his evidence on commission, but because the state, for reasons that are unclear to us and in the face of applicable case law, are doggedly refusing to cough up reasonable legal fees to represent Joffel van der Westhuizen. And my lady, he does need paid legal representation. He did act in the course and scope of his employment with the former state, and the current state, as the successor entitled to that state, is obliged to pay. And my lady, we take a dim view of the Minister of Defence's conduct and approach in this matter, and we would hope that they will change their minds, and change their minds quickly, because they are obstructing justice in this matter. Then there's 75 years old Craig Michael Williamson, former head of Security Branch Intelligence, 75 years old Eugene Alexander de Kock, former head of Security Branch's Flock Class Unit. In conclusion, my lady, this inquest is probably the very last chance that the families will get to reach a semblance of closure. They deserve nothing less than a full and comprehensive accounting with the past. Those are our submissions. Thank you, my lady.
Thank you, my lady. I just need to explain the funding situation. We have received funding from the Legal Aid South Africa. There are some aspects of it that we are not happy with, but I shouldn't mention them publicly. We will solve them with the Legal Aid South Africa. We so we can represent the family as well as the community. Since we began, we were originally instructed by Mr. Mbulelo Goniwe, as well as the broader community of Cradock. But there have been further members of the Goniwe family that have also requested us to represent them. It's necessary to mention their names, if anything, out of respect. The first is Yoliswa Goniwe, who is the sister of Matthew Goniwe. She is currently in an old age home. The second is Margaret Goniwe, Bulelwa Goniwe, Nomgcobo Jacob, Kholiswa Hasman, Patrick Goniwe, Bongani Mtseu, Voisile Goniwe, Zolani Goniwe, and Nomima Mjanga. These are the brothers and sisters of Matthew and Mbulelo. But for our purposes, they were living in the house that the court will be taken to tomorrow, which was placed under constant police surveillance. So, Your Ladyship, you are the fourth judicial officer to hear the story of the Cradock 4. Before you, there was, in 1987, an inquest before a magistrate known as De Beer. And then in 1993, a second inquest before a judge, I think the judge president of this division, Judge Zitzman. And then in 1998, there was a hearing before the Amnesty Committee of the TRC. And this is the fourth time the story is being played out before a judicial officer. But it's different this time, because there is at least the possibility that the full truth can be told, notwithstanding the limitations of a legal process. But there is also a possibility that the foundation for reparations can also be laid. There is also the possibility of closure from a perspective of psychological trauma. In relation to Mr. Goniwe, Mbulelo Goniwe, he will be testifying not only as a family member, but also as a comrade alongside Matthew and his other comrades in the Cradock 4 during the liberation struggle. He was a comrade of Fort Kalata, a comrade of Sparo Mkhonto, a comrade of Sicelo Mhlawuli. He survived the assassination, perhaps by the mercy of God, and he has lived to tell the tale, to remind the country not to forget the story of apartheid and its brutality. So he will be the main witness that we will be calling. But he will place this evidence in a larger context of history to show that Fort Kalata, Sparo Mkhonto, Sicelo Mhlawuli did not die in a political vacuum, but they had been leaders of a generation of activists. But beyond being leaders in the political sense, we must remember, Matthew Goniwe was a teacher, at some point a vice principal of a school. Teachers are important people in black society. They have always been. As torchbearers, what they do, they bring light to the community. They are also organizers. They bring the society or the community together. But there were also fathers. You heard from Mr. Vani speaking about the sons that will be testifying. These sons were 1 or 2 at the time when their fathers were taken away from them in very ruthless forms. There are also husbands. The wives will be, the widows are left alone to pick up the pieces. And so when one looks at this case, one should not view it only as a political contestation. There is a tendency to see these cases as a fight between right and wrong, a fight among political adversaries. And really little emphasis on the personal side of the loss, losing a father, losing a husband. So we will say, through the evidence of the experts that we will be calling, that there is both trauma that is intergenerational, that South Africa has not grappled with. And although the Inquest Act is limited in its scope, it should be interpreted through the prism of the Constitution, which is expansive in its scope. And therefore, we shall be asking your leadership to also make recommendations about reparations. But these reparations are also not limited to the children of those who were murdered or their immediate family members. They are broader and focus on the community, because the removal of the community leaders was also a traumatic event to the community as a whole. What they did, the leaders of apartheid, perhaps that's what they planned to do, was that they eliminated the leaders, but that elimination instilled a sense of fear that if anyone tries to resist against the system, their fate is pretty much sealed, similar to the fate of Mhlauli, Kalata, Mkhonto, and Goniwe. And so from 1985 up to 1994, that's approximately 10 years, you had a community that was gripped by fear, the Cradock community, gripped by fear of the system. Because not just of the murder, there were many people that the whites killed a lot of people, many people. They've been killing them since 1652. But under apartheid, they just killed many people. But this was a particularly gruesome murder. The murder of the Cradock 4 was an especially gruesome one. And perhaps that gruesomeness is an intentional gruesomeness, because the intention is not just to remove a life, but it is also to send a message that if anyone tries to be quote-unquote clever, this is what will happen to them. So there is something symbolic, therefore, in the targeting of the leaders, and something symbolic in the methods of that killing. Why did they choose this form of killing? Because they could have shot them or could have poisoned them. But they elected a gruesome form of killing that is preceded by torture. And here, most of this is known, most of it is known because it's been testified before in various forums. Just want your leadership to take the court to a statement that was made by Eugene de Kock in the TRC. There's an English translation. We are grateful to Mr. Vane's clients. They gave us this statement. It's a short statement, but it illustrates the point about these killings. And it is in page 60 of the translated versions. I've got no doubt these will all be made available in due course. So it's purporting to apply for amnesty at the TRC. This is what it says. So Eugene de Kock is applying. He says, I took over as commander of Flak Plus during 1985. And during this period, I received a telephone call from one Saki van Zyl one morning. I think his rank at that stage was captain, and I knew him from our Kufut days. And Kufut was also another just notorious branch of these guys. And I knew that he was stationed in Port Elizabeth. He contacted me at Flak Plus, and he wanted to know from me whether I had a contact at the ballistic unit of the South African police, since he apparently had a problem. Van Zyl informed me that he had a problem with a firearm which was used in an operation, and he wanted the ballistic features of the firearm to be changed. So they are now trying to disguise their murder. I informed him that I did not really have a contact, and I proposed that he throws the firearm into the sea. Whereupon Van Zyl's answer was that there were only approximately 120 of these weapons in the country, and that it was the weapon of a very good friend. Later during the year 1985, I met Van Zyl personally in Pretoria. Or could it be while I was in Port Elizabeth? Saki van Zyl then personally informed me that he was in command of the operation when Goniwe and the others were abducted. He shared with me information that he and his people were personally involved in the operation. They had, according to this information to me, ambushed Goniwe and the others and then abducted them. Van Zyl informed me that he personally took Goniwe and put him in a yellow vehicle. The vehicle apparently belonged to the security police. When Van Zyl told me about this incident, he also informed me that he was extremely surprised when Goniwe fought fiercely and resisted. During the struggle, Goniwe had apparently almost managed to grab Van Zyl's firearm from him. As they were struggling, a shot then went off, and it was through the roof of the yellow police vehicle. According to Van Zyl, Eric Winter was also present, and in the words of Van Zyl, he was drunk as usual. Goniwe and the others were then taken to a farm or a small holdings where they were murdered. Van Zyl further informed me that while they were busy burning documentation on the farm or small holding, Winter threatened Gert Lotz with death in case he would speak about the incident. And my recollection is that Van Zyl had said that Winter was also still drunk at that stage. Saki van Zyl was very worried about the firearm and had repeated it again, that it came from his best friend. A day or two after the incident, Van Zyl went to the Moyat Islands in the Comoros, where he went diving. He was apparently there for 14 days, and Van Zyl had then informed me that General Krapis Engelbrecht had taken over the investigation, and that he, for example, had confiscated all the traffic tickets that were issued to the yellow police vehicle. So, what we see from this statement is that obviously there are the people carrying the guns, doing all of the dirty work. But they thereafter report to the bosses at the top, and the bosses are then responsible for making sure the evidence disappears. And these are generals, people quite senior, high up in the army. But we know from what Mr. Vani also said that one of the unique features of this killing is not that it was brutal or that it was reported to the generals, but also that it was known politically at State Security Council. It was known by very senior people, including F.W. de Klerk. Now, we know who that he was. He was a so-called champion of the transition. Yes. But he has not, by the time he died, he had not told the nation about what he knew about the murder of Kalata, Mhlauli, Mkhonto, Goniwe. So who else was sitting there in this cabinet? Well, we need to find out in this inquest. So I would say your leadership is in a unique position out of all of the 3 previous occasions. And what roles did they play in the new South Africa? These people that were sitting in the apartheid, in the last apartheid cabinet, what roles did they play in the new South Africa? Did they project themselves as having always been opposed to apartheid, or did they admit and confess that they also had a murderous side to them? Now, this is a crucial question that your leadership has been bestowed to answer by history. History has asked your leadership to help us uncover these people who, and these are not my words, but these people who during the day do one thing, but at night they do something different. Now those apparently are the words of Magistrate De Beer to Arthur Chaskalson at the end of the inquest, when his conscience couldn't live with him, that he had found that no one was responsible. And he confessed to Arthur Chaskalson that it seems to me that certain people do one thing during the day and another during the night. The same applies to de Klerk and his friends. They clearly did something else during the day and another at night. And your leadership needs to find out who else is still alive that also did one thing during the day and another at night. Was wearing a suit and a tie during the day, but had blood in his hands at night. So, therefore, your leadership, what we are asking is that this is also a moment of legal reconstruction, is to reconstruct the facts and put them correctly. Because our expert, his name is Professor Langa. He is from Wits University. He has a PhD in psychology. What he says is that there are 2 sides to healing. So there's one, the compensation. So you've lost your father, let's give you money for it. But there's also the other side of psychological. But that one begins by knowing the truth, knowing everything that happened. And then you can start healing. And those 2 need to go together. Now, unfortunately, the post-apartheid order has not enabled either side to heal. So, because no one has been interested to find out, what happened to de Klerk's friends, and no one has been willing to answer the question. Well, how do we explain to Nyaniso Goniwe what happened to his father? How do we explain to Lukhanyo Kalata, what happened to his father? So that question will be answered here. Now, we know because of delay that there will be questions about direct, indirect evidence, hearsay, double hearsay, triple hearsay. But luckily, this is not a criminal trial. I hear there is a long list of criminal lawyers that will show up here. But they're going to be disappointed because this is not a criminal trial. The standard of proof is not beyond a reasonable doubt. So, evidence that would otherwise be inadmissible in a criminal trial is admissible in an inquest. And that actually should be the case, because these murderers, these Yaki Fansel, these people that were killing a lot of people, they were able to hide what they did because no one else could find out. I mean, if you stop someone at 11 p.m. at night and then you go and murder them, then you burn the car and then you throw the gun into the sea, no one else is there. You are the only one who survives to tell the tale. Most of us have to reconstruct that story by secondary sources. And that's why in an inquest, it's perfectly logical to admit evidence that would otherwise be inadmissible in a criminal trial. So we would ask your ladyship to adopt that broader lens into the admission and evaluation of evidence. We have also asked, beyond General Olomisa, beyond beyond the expert, we've also asked General Olomisa to testify as to his knowledge. He was in a unique position in the late 1980s as he was not a state president, but I think the chairman of the military council, yes, of the independent state of the Transkei. But he received the dossier that contained information about what had transpired to the Cradock 4. And he will explain what dossier he received, what he did with that dossier upon receiving it. Now, he's obviously an important person in today's South Africa, having been a deputy minister before and a member of the opposition for many, many years, and now the Deputy Minister of Defense. Now, when it comes to Mr. Mbulelo Goniwe, we've said that something that places him in a different perspective is the fact that he's not giving secondary or hearsay. He's involved at the time the events were unfolding. His name is also mentioned in the note that was circulated for permanent removal, the so-called signal. His name is mentioned there in the signal for permanent removal. He also lives in the house that is bugged and surveilled regularly. But he has survived miraculously. And very few witnesses will be able to do what he can do simply because here, as Mr. Vane says, the witnesses they are calling at the time were children. But he was already an adult and an activist, and he can therefore shed light as to what happened. Now that takes me to this point that we were trying to debate in your ladyship's chambers, which is, well, how should your ladyship then deal with the fact that the Defence Force has not yet made a decision or a final decision or reconsidered this decision on funding? Our view is simply this. Mr. Mbulelo Goniwe should be allowed to give his evidence. He should not be constrained by not implicating people. The people that have not been funded yet must make a decision as to whether or not they will cross-examine now or cross-examine later. What we think is intolerable is for this inquest to be held back because the Department of Defense has decided not to give funding to certain people. That is an issue that we say is a side issue for the inquest. They must pursue their dispute at the Defence Force and hopefully get funding. Or they must ask Legal Aid South Africa for funding. Minister of Justice, I was told, is in court. I saw her. She can deal with that.
But the point was made that the fact that the party or parties concerned can have an opportunity to cross-examine at a later stage will not be complete remedy, because the parties will be denied the opportunity to object to evidence at the time of this.
No, they won't. They will be in court. They can cross-examine. The issue is about funding. It's not about their presence in court. They can be in court. The fact of the matter is that they can be in court, they can sit, they can cross-examine. There's no one is denying them that right. So your leadership is not denying them anything. What they're complaining about is money. That's got nothing to do with the inquest. They must go and fight that fight on the side. But the inquest must proceed. Because one must remember this issue. You know, we come 40 years from 1985. 40th anniversary this year. Now, when is the Department of Defense going to solve this? We were here, my lady, last year in September, before your leadership, when we agreed on this date now. So, why then did they not solve it for the last 7 months, solve the problem of the funding? We solved it. We also didn't have funding. We had to go to court. We brought an application. It ultimately resulted in funding. So they can't say, no, we will be denied. The only reason they will be denied is because they will leave the courtroom. You see. But that is their problem, if they decide to leave the courtroom. See. Now, the same applies to the police. The police are funded. The implicated members of the police force are funded. There is a different issue that they are not fully prepared, etc. But they are funded. The funding has been approved. So they have no reason to leave the courtroom. And they can sit, they can object. But what Mr. Goniwe will find intolerable is a scenario in which he is told, speak but do not mention names. That's an artificial form of giving evidence. He has to mention names. And I believe the same thing with the children of Matthew Goniwe, the children of Fort Galata. They should be allowed to speak freely and to tell their truth from their perspective. If they have to mention names, so be it. What we cannot do is to run a trial in which names are not mentioned. Names must be mentioned because that is the nature of the animal. It's the nature of the beast that if people have been murdered, they have been murdered by people. If others were planning the murder or responsible for covering up the murder, then they should be mentioned. So we would therefore ask your leadership that you rule that there are no restrictions to the evidence that will be given. Certainly no restrictions based solely on the fact that the Department of Defense has not yet approved the funding of the former members of the Defense Force. But evidence can be given in full. That would be just an equitable answer. There is obviously the possibility of a postponement of the evidence part of the inquest. Now, that is open to your leadership, but we say that you should consider that really as your last resort. The most preferred outcome is that those witnesses that are available and ready should give their evidence without any restrictions. I know Mr. Vande has a different approach to this because he says the evidence can be given provided it doesn't implicate, except if the implication happens through publicly available sources. But I submit that implication is implication, whether it's direct or indirect. And what is clearer and better is that there is a clear ruling from the court that witnesses, particularly family witnesses, are not restricted from giving evidence of any kind.
Because I think also there will be the issue of what weight the court places on their
Yes.
say-so, on their evidence.
Yes, there will be that issue. But certainly, it's not fair to constrain these witnesses. They should be allowed to say their say. And the choices that General van der West says he must make those choices. So we would therefore ask your leadership that the proposal of the NPA, which is tomorrow to do an inquest in Cradock, we support. And if there is time to also visit the crime scene, we would support that. But on Thursday, we would like to call our first witness. Mr. Goniwe is ready. He would like to testify. He wouldn't like to be constrained in any way. He can be cross-examined either on the day or on the following day. And we would therefore ask for that ruling. We don't insist on being the first. The NPA can go first, or Mr. Vani can go first. But whichever order of witnesses is agreed, but we would like the first witness without constraints to testify on Thursday. Thank you, my lady.
Thank you, Mr. Mr. Celia, who's next?
I will be brief. This is a highly emotional investigation and relating to the very tragic deaths of 4 people. We acknowledge that, and what I can inform your ladyship of is that my instructions are clear that we will fully cooperate to assist your ladyship in all manners possible with the process to reach the objectives set out in Section 16 of the Inquest Act. The only situation that may arise, my lady, is the protection of the clients that I represent, that their rights are being protected, because 2 wrongs do not make a right. One cannot take away their fundamental rights of fairness in process because of the serious accusations against certain, mostly other members of the South African Police Services. But as a starting point, your ladyship can accept that we will fully cooperate as far as possible. That's why we already, although only receiving instructions a few days ago, we already agreed in chambers that we will participate in the present proceedings. We will participate in the inspections in loco, etc., to at least have the proceedings started and to utilize court time as good as as possible.
As optimally as possible.
Yes, as fruitful as possible. I, however, just have to sound a word of caution in this regard. We should not, with respect, because of the seriousness and tragic nature of what happened, allow that to interfere with the fairness of the process and to lose sight of the objectives of an inquest as set out in the Inquest Act, more in particular Section 16 thereof, in the present proceedings before you. I don't have to repeat it. The objectives of this inquiry are 4-fold. To a large extent, 3 of these objectives have already been satisfied in the previous proceedings relating to the identities, the causes of death, the dates of death, and to a large extent the 4th requirement has also been met. It's basically only the question whether in these proceedings you can now in fact find names to perpetrators who may be criminally responsible. That's basically the only new issue, and these proceedings before you are indeed reopened proceedings. So the previous proceedings, more in particular the inquest dealt with by the Honourable Zietsman JP, still stands. And in that sense, we would urge you not to allow the proceedings to go beyond what is really necessary to determine the issue that is still outstanding, the objective that is still outstanding, and the question that is still to be answered. When reading, after receiving instructions, some of the statements, I had some difficulty to understand the relevance and or the motivation of some of these allegations in statements. I think I understand it more or better now after hearing my learned colleagues in their opening addresses. And it appears to me that you can just go and look at the word reparation that was used, that you will be asked, apparently, at the end of the proceedings, to consider granting an order relating to reparation. Now, with the greatest of respect, I differ, and my submission is that reparation is not part of the inquiry before you. It hasn't been provided for in the Act, and it has not been decided in any court, to the best of my knowledge, in any previous proceedings of this nature, that a court should investigate and consider and then determine reparation with reference to who may be entitled thereto, what form reparation should take, etc., etc. And the only caution, I understand that your ladyship have a wide discretion in allowing or disallowing evidence. The word of caution is just be careful not to allow floodgates to be opened, allowing evidence that may then take weeks to put before you, relating to an issue or issues that are not relevant for purposes of the inquiry that we are busy with, and that you were instructed and or requested by the Minister to consider and or to deal with in the reopened inquest before you. An issue that our learned colleague or colleagues raised, the standard of proof. It was submitted to you that because of the lesser standard of proof required in inquest proceedings, it will have an influence on the admissibility of evidence. I take very serious issue with that. It is correct that the standard of proof required in an inquest is indeed lower than in a criminal trial. You only need prima facie evidence to come to conclusions and or to make findings. Whereas in the criminal proceedings, of course, proof beyond reasonable doubt is required. But that has no influence with respect on the admissibility of evidence. I will accept that you have a discretion to provide more latitude to parties in that regard. But that is the basis for that latitude is clearly not in the fact that a lesser standard of proof is required in the Inquest Act. It should more be seen, I would respectfully submit, in the more informal process that we follow here. It's more an inquisitorial process before you than an accusatorial process than in a criminal trial. But certainly the rules of admissibility remains very strictly the same as in a criminal trial. You can also have regard to Section 8 of the Inquest Act, where this is largely stated more in particular Section 8.2 of the Inquest Act. As far as the submission or suggestion that you should allow witnesses to testify not bearing in mind the restriction that you already gave in a previous meeting of legal representatives in a case management meeting, I respectfully submit that that loses sight of another fundamental principle that you have to bear in mind, and that's the fairness of the process. My position at this stage, or the position of the 3 individual members of the police that I represent, is a bit more favorable than the position of the Defence Force person, because we have, as indicated to your ladyship, we have been granted the right of legal representation very recently. But obviously, legal representation does not only mean a person sitting in court. It means effective legal representation, and at least I would respectfully submit it would include the right of the representative to properly prepare before he represent his or her client. And there's absolutely, your ladyship has seen the magnitude of the documentation and evidential material that the parties intend to put before you. There was absolutely, it's humanly impossible to have properly prepared in a few days for cross-examination of the relevant witnesses. As far as the representative of the Defence Force member is concerned, he will make his own case. But to suggest with respect that it's a question of money, it's his choice to sit in court or to leave, that, my lady, is with respect a very unconstitutional submission, at the least I would submit. There's a further issue, however, that was not raised and referred to. It's common cause between the parties. It was raised before you in chambers. There are still documentation, and on the face of it, although nobody saw the documents yet, maybe extremely important documents. It must still be declassified, so not even the state has seen those documents yet. But to commence with implicating witnesses implicating certain individuals, without having had the opportunity to see and to study those documents and to at least deal with it in consultation insofar as it may be relevant to a particular person, is highly improper, I would submit, and surely highly unfair. And it may also be a waste of valuable court time. There may be issues transpiring from those documents, or some of those documents, that may have the effect that the whole direction of this inquiry may be changed. I'm not saying that is so. I have no idea what those documents are, but the fact that it had been regarded as relevant, it must be declassified, so it appears to be secret, or top secret documents emanating from the security forces. So on the face of it, it may be very important documents. And I would respectfully submit that to commence with witnesses implicating certain individuals before any party had the opportunity to study those documents will not be the proper way forward in this inquest. And I would therefore submit that at this stage, the proceedings should proceed on the basis as envisaged previously by you in a case management meeting, that inspections can be done, witnesses who do not implicate any person can be allowed to testify, and that you should not allow the process to go further. As far as Mr. Varney's submission that witnesses can be allowed to give evidence implicating a person as long as the basis of the implication is some public documents and or public material. The problem is, of course, if Mr. van Zyl is not here and the evidence in chief is led on that basis, he will lose his right to object to that evidence. Maybe there's a dispute whether that particular evidence indeed has as its foundation some public document and or some public information. And with great respect, to take that right away from some of the most important implicated persons, because obviously Mr. van der Westhuizen or General van der Westhuizen is probably the most implicated person at this stage, at least on paper, and also based on the findings of the Honourable Zitzman JP in the previous inquest. I would respectfully submit is highly unfair, and it will also be unfair to my individual witnesses to allow that under circumstances that I didn't have the opportunity yet to go through the documents, and in particular those documents that had not even been disclosed to us at this stage. So my respectful submission is that we should proceed, or you should allow parties to proceed to deal with evidence and to lead evidence on issues not implicating parties, and then disallow further evidence. Hopefully we can resolve, and what I heard from the state during discussions we had, it appears that this issue relating to the legal fees of the Defence Force may be resolved in the next couple of days. So it's not a situation where one will have to postpone for 6 months or a year in order to resolve that issue. Maybe one last aspect. There was a suggestion, I think, in the meeting before we went to to see you in chambers, that maybe witnesses can be led in evidence in chief and then cross-examination can stand down. The practical difficulty, what I've experienced in previous proceedings where such a practice was followed, was that it was very unsatisfactory to at some stage have 5 or 6 or 7 witnesses giving evidence of in chief and everything stands down. I respectfully submit that that is not a process or a procedure that you should allow. If there's one witness, one can maybe accommodate that. But if that is the pattern of process, then I would sound a word of caution that may put the parties and also put you in a very difficult situation eventually, as you please.
Yes, Mr.
Court pleases, my lady. And yes, I again confirm that I appear for General van der Westhuizen, and at the outset I would like to put it on record that he denies ever authorizing or ordering the killing of the deceased. That is what his defense boils down to in respect of these proceedings. It is further common cause that at this stage he has been denied legal representation at state expense. It is further the situation that an urgent review application was filed during March of this year after the refusal or the reasons were provided, and after we inquired, or my attorney inquired from the Defence Force whether there is an internal process of appeal, to which request we only received an answer on the 8th of January this year, and thereafter the review proceedings were launched. It was enrolled early April, and the matter was struck from the roll due to a lack of urgency, despite the fact that it was argued that the proceedings are enrolled for today for 3 weeks. The presiding judge struck the matter from the roll. It is will now have to be allocated on the normal opposed motion court roll, despite requests, numerous requests also in writing from my attorney to the registrar at the High Court, the North Gauteng Division. We have not been allocated a date on the normal opposed roll. That is the objective factual position of my client at this point in time regarding his funding. That is also despite the fact that very serious allegations are leveled against him. If we, Your Ladyship, just consider the opening address of Mr. Varney, who also coincidentally supports the view of General van der Westhuizen that he should be afforded legal representation at state expense, but having regard to paragraphs 29 to 39 of the opening address of Mr. Varney, one is able to gather the seriousness of the allegations against General van der Westhuizen, that he was a member of the Joint Management Committee, JMC, that is in paragraph 29. That specific meeting he apparently chaired. Then the signal that is referred to, that is paragraphs 35 and 36. And eventually, in paragraph 39, the allegation is made that the key masterminds behind the operation sat on the Eastern Province JMC. That is the same committee that referred to in paragraph 29 that he apparently at that stage chaired. So the allegations against my client is of a very serious nature. He is directly in the firing line, but currently he has not been afforded legal representation at state expense. We have also right from the outset indicated to Your Ladyship that we have an instruction to assist the Honourable Court in making arrangements for dates and logistical arrangements. The position is still exactly the same. With regards to the question of money referred to by my colleague Mr. Nkaitobi, I can recall at one of the first case management meetings that I attended, he indicated to Your Ladyship that their biggest problem was money. His problem has now been resolved. My problem is still money. So his position fortunately changed, but mine unfortunately not, or that of my client. So we are not in a position, my lady, to represent General van der Westhuizen during the balance of the proceedings at this point in time. I'll address Your Ladyship on that. I can do it now. But the fact of the matter is we do not have the funding to represent him during these proceedings, except that due to the fact that we have indicated right from the outset that we don't want to, my client doesn't want to be obstructive. We have no objection, and we've indicated this morning to the other legal teams, and especially Mr. Coltman on behalf of the NPA, that the proceedings today, we have no problem there with the opening addresses, so that we also have the opportunity to put our situation on record. We do not have any objection against the inspection in loco. The allegations against my client is such that it doesn't put him, if I can, in that area or that part of the investigation. We do not have an objection if that proceeds. We do not have an objection if the evidence of any witness proceeds, as long as that witness does not refer to my client. Because we submit that we are entitled and he is entitled to be represented. So already provision has already been made that the proceedings will most likely be postponed to a later stage for the hearing of the evidence of witnesses implicating certain persons, including my client, and we submit that that arrangement should be held in place. And in the meantime, we have no objection that the evidence of any other witness proceed. there was a long list of witnesses provided at the commencement of the proceedings or prior to the proceedings in September, and any of those witnesses can give their evidence as long as my client will not be implicated either directly or indirectly. I don't want to repeat arguments that were further earlier traversed, especially with regards to the submissions made by Mr. Sillier, but the fact of the matter is that I'm entitled to be present, or his legal representatives is entitled to be present during the proceedings, and not only when certain witnesses give evidence, or that a situation results that a witness give evidence but his legal representatives are not able to be there. I also base that submission, my lady, on the provisions of the Act, and the provisions of the Act, with all due respect, your ladyship is bound to. Section 8 of the Inquest Act, 8 sub 2, provides that save as is otherwise provided in this Act, the laws governing criminal trials shall mutatis mutandis apply to securing the attendance of witnesses at an inquest, their examination, the recording of evidence given by them, the payment of allowances, and then lastly, the production of documents and things. So the rules governing criminal trials, and that includes the evidentiary rules, of an inquest is the same as in a criminal trial. There is some exception, and that is, for example, that your ladyship can allow statements to be introduced. That is, as a general rule, not allowed in criminal trials. So in that regard, you clearly have a discretion to allow statements subject thereto, that the statements are confirmed under oath, and certain other requirements that the Act provides for. Then the other important issue, of course, my lady, is that the Act further provides that any person that has an interest in the course of the inquest, and I refer to subsection 11.2, under the heading examination of witnesses, any other person, the subsection 1 deals with the public prosecutor who may examine witnesses, and then subsection 2, any other person who satisfies the judicial officer that he has a substantial and peculiar interest in the issue of the inquest may personally or by counsel or attorney put such questions to a witness giving evidence at the inquest as the judicial officer may allow. Now, I submit, my lady, subsection 11.2 read in conjunction with subsection 8 sub 2 clearly should be interpreted on the basis that a legal representative might be present at all relevant times when a witness gives evidence to object thereto, as can be done in a criminal trial, and that any departure from that process, in my submission, would not only be irregular but unconstitutional. It is common cause that my client is implicated. It was confirmed during a case management meeting that he is in fact regarded as a suspect, and in order to protect his rights, it is submitted that evidence of any witness implicating him can only be adduced once he is properly legally represented. Lady, I submit that that disposes of the proposal by Mr. Nkatobi that witnesses should be allowed to be called and give evidence as they wish at this point in time. And I want to emphasize that my client is not obstructing the process. He is merely requesting your ladyship to make a ruling that the evidence of witnesses implicating him stands over. Lady, there's only one more aspect that I would like to deal to. I'm just going through my notes quickly. Yes, the only further aspect, my lady, is of course something that was also raised by Mr. Sillier and in your chambers this morning, that there are a vast number of documents that is in the process, hopefully, of being declassified by the, as I understand it, the South African National Defence Force. Now that is where my client was employed. He is the only person in these proceedings that was employed by the South African Defence Force at the time, the then SADF, and most likely if there's any document that is relevant with regards to the conduct of a person in the employ of the SADF at the time, it might be extremely relevant to the conduct of my client. And in order to be able to cross-examine any witness at this stage without having had access to those documents and the opportunity to peruse same and get instructions thereon, I submit would also be prejudicial to my client and would also infringe his constitutional rights to properly give instructions to his legal representatives and for them to be able to cross-examine such witness. So, my lady, in closing, I submit that in each common cause there are still a number of documents that have not been provided to us. My client will be prejudiced if witnesses will now testify without him being able to properly cross-examine and be in attendance through his legal representatives. And as I've indicated, he denies any unlawful conduct, and he should be able to properly present his case before your ladyship. Your ladyship will, in the end of the day, have to make a very important decision, and that is whether any person can be held liable for the death of any of the deceased. And that might have, it speaks with all due respect for itself, that might have a very important implication on my client without conceding that it will be so, but that is what your ladyship needs to investigate. Lady, the other situation that we've also previously raised with regards to my client, and it was also, I think, in Mr. Varney's argument, he is not in a very healthy condition. He might have problems attending these proceedings. He has serious back problems. And it's in any event for him, with all due respect, and by my judgment, after I've seen him, it won't be able for him, or he won't be in a position to physically attend every day in order to defend his case if he's not properly legally represented. So, my lady, my suggestion then finally that the proceedings may proceed as I've suggested, and as soon as we hopefully very soon resolved our position with regards to funding, then the witnesses can be called that might implicate my client as a court pleases.
Thank you.
You will deny any involvement, directly or indirectly, to accentuate the word
Just that,
death.
just that again, I didn't hear you when you started off. Yes. Okay.
I act for Mr. Barham to proceed.
Thank you.
Not the to proceed that's deceased.
All right.
You will deny any direct or indirect involvement or obstruction and accentuate the word death of the deceased. That, in fact, he is actually takes serious exception at the allegations. Thank you.
Thank you, Mr. De Meyer. Yes, Mr.
May
Skuman.
it please the court, my lady. As previously stated, I appear on behalf of Mr. de Kock. My lady, I will also be very brief, as my learned colleagues addressed most of the issues that needed to be canvassed. My lady, firstly, my previous learned colleague made a suggestion that the parties agreed on a date. Insofar as that might implicate or state that any of the clients or the persons of interest had any delay in this matter, my lady, we just want to place on record that especially Mr. de Kock, as soon as he received the summons, attempted his utmost best to get legal representation and funding as soon as possible. I mean, we instituted no less than 3 urgent applications, and luckily Mr. Notley from the local state attorneys greatly assisted in that regard. So just to place on record that there's no delaying tactics from any of the parties here. We attempted our best to get the legal representation as soon as possible. And regarding the evidence being restricted,
Just remind me what the position is at present, Mr. Schoeman, regarding legal representation for Mr. de Kock.
we were provided with legal representation, I also believe about a week and a half ago. And this is where I just want to address the court on the allegation or the statement that evidence will be given with restriction. Now, I don't think it's any of the persons of interest to say that we want to restrict any evidence. The fact of the matter is, merely weeks ago, we received thousands and thousands of pages. I believe it's more than 9,000 pages. So there's no intention to restrict any of the evidence. It's just that we won't be able to sensibly participate in these proceedings if we haven't even had the opportunity to go through the bundles that has been presented. So we just need the opportunity to go through everything to participate in this matter. But based on the instructions from client is that we will provide our full cooperation and hopefully help and assist to answer any questions. But I agree with the sentiments and statements by my learned colleagues that until we had the opportunity to at least go through all the documentation, that no evidence can be presented that implicates the client, as it pleases the court.
You have no objection to the to inspection in loco being held at the two suggested or three suggested places, as well as the leading of those witnesses will not be implicating.
None, my lady. May I please?
Thank you, Mr. Schoeman. Anyone else who's...
Ladies, if there are other parties to make submissions, could I have an opportunity to respond to some of the points made by my learned colleagues?
Let's see if Mr. Coltman has anything to say.
Milady, your ladyship will recall that I did not attend or could not attend the case management meeting of the 19th of May this year. But I have been advised by my colleague, Mr. Governor, who attended the meeting, and I understand, having read the minutes of that meeting as well, that there had been an agreement. And I beg your pardon, in fact, your ladyship had made a ruling supporting the request that had been made by Mr. Varney, that evidence be led by the family witnesses regarding evidence that appears in publicly available documents. And I'm sure Mr. Varney would put it much better than I'm putting it. And all these objections that are now raised was never raised at that meeting.
Yes, but the agreement has always been that evidence that does not implicate the persons of interest will be introduced until such time that they are on
that was as I understand,
benefits of legal representation.
Indeed, my lady, and that was I think the general principle, except for the qualification made to that submission by Mr. Varney, and which ruling your ladyship had made in that regard. So that's the first point, and I'm not going to expand on that, but I just wanted to also point out, number two, regarding this issue about evidence that's not available yet, etc., etc. Your ladyship will also recall, and I'm sure my learned friends would agree with me, that it had been stated on several occasions by the members representing the persons of interest that they would not read any documents until the issue of legal representation had been resolved. So whether the documentation is available or not, they were not going to read it in any event. So that needs to be made clear. And just with regard to the issue, the last statements or submissions made by Mr. Skuma and my learned friend Mr. Skuma in respect of the vast amounts of documentation. We will have a pre-trial. It has been agreed that we have a pre-trial meeting after the opening addresses so that we can resolve all these issues regarding the record, the documentation, etc. But I just want to point out that the record had been furnished, the first part, that is the De Beer inquest record in regard to the De Beer inquest and whether there may be outstanding or missing documents, that issue can be resolved, including the complete Zietsman record, had been provided to Mr. Versage. And I think during July last year, to all the legal representatives, in fact. And I can go and look for the exact date, if necessary. With regard to the TRC evidence, that was also, I remember my previous colleague, Ms. Bosman, she sent these documentations to everybody. And I remember that at one stage she sent links to where these documents in respect of the TRC evidence could be downloaded or accessed.
I don't think we should go there, Mr. Constable,
Yes, thank
because
you.
there's also the issue of parties complaining that they had not had funding for legal representation, and therefore it would be
Yes, thank
difficult
you.
for them to...
Then let me leave it at that. Then.
Right. Anyone who's planning to reply, although we...
If I seek your indulgence.
Yes.
It appears that my colleagues are seeking a ruling from you in respect of what is it the family members may say and may not say. And it appears that my learned friends representing the persons of interest simply don't want any references to them made, or certainly no views expressed about the role they play arising from the documents. Melody, as Mr. Coltman has submitted to you, we will also urge you to stick with the ruling that you made in that case manager meeting, that the family members would be free to make reference to publicly available documents, namely the 2 inquest records and findings, and the TRC proceedings and the findings arising from the work of the Truth and Reconciliation Commission. Because, milady, if that ruling is abandoned, we have a fear that this inquest, at least the first part of this inquest, could turn into something of a farce. And the reason I say that, milady, is because we are then expected, the family members, are then expected to pretend that that information that is publicly available, those 2 inquest records and the findings, and the Truth Commission record, that they simply don't exist and that they must be ignored. And my lady, that would turn these proceedings into a farce and into a pretense. And I don't believe that this court would wish to go down that road. My lady, our clients are the wives of the Cradock Four. They were not on the scene. They were at home. Our clients are the children. They weren't on the scene either, and they were mostly young. Some 2 or 3, some hadn't even been born. So clearly they're not in a position to engage in any direct implication. But to suggest that they must pretend that the De Beer inquest and the Zietsman inquest and the findings arising from them, as well as the proceedings before the Truth Commission and the amnesty proceedings, would with respect turn this proceeding into a pretense which would be the subject of much ridicule. Lady, this is an inquisitorial process. It's an inquiry that you are in charge of. Yes, indeed, you have to respect procedural fairness. But such considerations should not stop the family members testifying about what they know about their perspectives on hearing about the findings emerging from the Zitzman inquest and their views of what happened in the Truth Commission. And then we would simply urge you to stick to your guns on that matter. We will also take the extra effort of providing references to the particular documents or findings that are referred to. As Mr. Coltman has said, these have been provided many months back, and in some cases years back. Although we don't have a full paginated record, which will make it a little more difficult to make reference to the documents, we will nonetheless try. And as mentioned, if we have a pre-trial conference this afternoon, maybe those issues can be resolved. Those are submissions.
Thank you. Mr. Ngcobo, your position is somewhat different to the one alluded to by Mr. Vani, in that the witness you seek to call will do more than refer to public documents.
Yes, my lady, he will. He is in a slightly different position because on some of the events he's an eyewitness, he was personally there. But he also does have references to publicly available material. But my problem is I'm unable to call him for part and not to call him for everything, because I have to recall him anyway when he is to be cross-examined. And it seems that I should either have the right to call him, and then the consequences for our learned colleagues, we deal with those, or then I tell him that he must come on a future date. Those seem to be the stark options. I cannot see that he can be called for part and not for the balance. I've just gone through the statements that Mr. Vani's clients submitted. The bulk of those statements actually don't even mention the names, particularly the statements of the widows. It's the statement of Mr. Lukhanyo Calata that's lengthier and meatier and provides actual names, but not from his personal knowledge, but from what he has read. But this needs to be clarified now, because what is going to happen is that he will testify, and then 5 minutes into his evidence, there will be an objection. And they will say, no, he is implicating us, but I want to object because it's hearsay evidence. That makes the proceedings even more of a fuss.
Are you referring to Mr. Calata?
Yes, I'm talking about Mr. Calata. I'm saying if he can testify and implicate in this way, I don't understand why my client cannot testify and also implicate people in this way. But he's got personal knowledge. He wants to testify. He's ready. The issue we have now is our learned friends, those ex-members of the police force have got the money. The issue now is we got the money too late, and so we need more time to prepare. That's really their issue. The defense force, I understand, the department has decided not to give them the funding. But I'm saying that should not stop in the way of the inquest. The inquest must proceed. They must continue with a parallel fight with the department. But I would like also to call my witness, but on the express understanding that he will implicate General van der Westhuizen. I don't want to pretend about that he won't. He will.
You have other witnesses that you will be calling apart from?
Yes, yes. But the one I'm clearer now about is this particular witness. I still have to take instructions on the others, but I can't commit on those.
Yeah, I just want to put it on record. It's not our approach that a witness should not be allowed to say what the witness wants to say. That we totally support, but just at the appropriate time. Thank you.
Okay. I think I am in a position to make a ruling on this aspect, and that as agreed upon previously, and a ruling made in that regard, that the inquest should proceed as it has done today, as was scheduled, and that only those witnesses will not be implicating the persons of interest, especially those that, especially the one in particular who has not received legal funding or fund for legal representation, should not be led, but that should be done at a later stage. So that is the ruling that I am making, that the inquest should proceed as planned, and that only those witnesses who will not be implicating those concerned should be led, and that includes witnesses who will testify based on publicly available documents. Those can testify.
As a court.
I think the next thing now,
So we're crystal clear.
Yeah.
Does your ruling say that family members may not refer to publicly available documents?
they may.
So that they are able to. I beg your pardon, Melanie.
And shall we agree or discuss now what time or can we do that at a later stage, or can you come and see me in chambers with a suggestion as to when we should meet?
Certainly, I think it would be more appropriate for us to take the adjournment, and we can meet in chambers so we can discuss
All right.
the inspection in local.
You can trash it out amongst yourselves in the meantime, and then you can come with a proposal, a suggestion. Already there. Could we adjourn?
Why did you want to? No, because the problem was, I don't know whether we were going to address the thing about